major Second Amendment case.
Members of the Senate are focusing on gun rights in the wake of the Supreme Court's Bruin decision.
Major Supreme Court ruling.
Everybody has a right if they're a responsible adult.
A new gun law you were not warned about. What if your firearms could be taken from you, not because you broke the law, but because someone made a phone call? No judge, no warrant, no hearing. Just a knock on your door, and your rights are gone in seconds. That scenario is no longer a warning. It is real, and it is already happening. On October 16th, New York Governor Kathy Hochul signed a law that triggered immediate gun confiscation protocols with no delay, no oversight. The rules have changed, and if you own a gun in America, you need to know how fast this could reach your state. And we're breaking it all down so you stay informed, protected, and one step ahead. Let's get into it. Chapter 1. The law took effect instantly. Most laws go through a phase-in period, giving people time to understand what is changing. Not this one. The moment Governor Kathy Hochul signed Bill A-00544B, it became the law of the land in New York. No waiting, no public notice period, and no chance for gun owners to prepare. One signature, and the rules changed overnight. The bill was signed on October 16th and became active immediately. Law enforcement agencies received instant authority under the new statute. No public rollout, no grace period, and no opportunity for legal pushback beforehand. This law expands a 2020 measure but removes discretion and adds force. This was not a small administrative change. It was a sudden power shift, a quiet legal move with enormous real-world consequences. Every gun owner in the state went to bed believing one system existed and woke up living under something far more aggressive. Chapter 2. Confiscation is now mandatory, not optional. Before this law, officers had the option to remove firearms during certain calls, depending on the situation. Now they must do it. There is no judgment call, no weighing of evidence, and no need to find danger first. If officers respond to what the state calls a family violence situation, they are legally required to seize all firearms present, along with the owner's carry permit. Officers must confiscate firearms if they suspect a potential risk. Confiscation does not require a crime, injury, or proof of wrongdoing. Carry permits are also seized automatically without a hearing. The law relies on perception, not verified threat or factual evidence. This is not about someone threatening harm or brandishing a weapon. This can happen during a verbal dispute, a misunderstanding, or even a false report. A neighbor overhears shouting. Someone calls the police without knowing the full story, and suddenly your rights are treated as forfeited. The state did not wait for due process. It erased it at the front door. Chapter 3. No warrant, no judge, no due process. One of the most alarming features of this new law is how it bypasses the judicial process entirely. Unlike red flag laws, which at least require a judge's signature based on an affidavit, this law removes the court from the equation altogether. It places complete authority in the hands of responding officers without oversight or legal review. No judge is needed to authorize the confiscation of your firearms or permit. Officers do not need probable cause, only a perceived concern. There is no requirement for any official charge, just a call or report. The law removes independent review, replacing it with on-scene decision-making. Imagine a law where a single officer's opinion carries more power than a judge's ruling. That is exactly what New York just implemented. Officers are now the first responders, the legal interpreters, and the enforcement mechanism, all in one. It is not an exaggeration to say that due process is being erased from the moment police arrive at your door. Chapter 4. One accusation can take your guns. What used to require evidence now only needs a whisper. Under this law, you do not have to be convicted of anything or even arrested. The entire confiscation process can begin based on nothing more than an accusation or the officer's feeling that something might be wrong. That feeling alone is enough to strip away your Second Amendment rights. No criminal act is required for your firearms and permit to be taken. Reports can come from uninformed third parties, like neighbors or passers-by. Police do not need context or confirmation, only a call and a concern. This policy allows confiscation based on hearsay, not facts. This level of authority transforms officers into judges and a jury. It turns vague accusations into tools of state power, where you are forced to prove your innocence long after your rights have already been stripped. In a free society, rights should never be lost before evidence is reviewed. But New York has flipped that principle on its head. Chapter 5. You must prove innocence to get them back. Once your firearms and permit are taken, the burden does not fall on the state to justify it. Instead, you must prove that you are still legally eligible to own a firearm. And the timeline for this has changed. What used to be a 48-hour review window has now expanded to 120 hours, 5 full days without access to your firearms or permit. The original law gave law enforcement 48 hours to return firearms if appropriate. The new law expands that window to 120 hours or longer, if the state chooses. To get your property back, you must prove you are not a prohibited person. The state is not required to offer a hearing before or after the seizure. This reversal of responsibility is dangerous. It treats lawful citizens as if they are guilty until proven innocent. And by extending the timeline, it normalizes this treatment, pushing it further out of reach. What begins as a misunderstanding can become a week-long ordeal where your rights are not just delayed, but denied without formal process. Chapter 6. Danger has been redefined. New York's law expands the definition of danger beyond anything we have seen before. Now, an officer doesn't need to witness violence, threats, or even physical distress. All they need is a belief, not proof, that you may be dangerous to yourself or others. This belief can come from third-party comments, vague body language, or even your past medical history. Danger is no longer based on criminal behavior or threats. Officers can act on assumptions, not evidence or complaints. No psychological evaluation or doctor's input is required. Anything from silence to emotional distress can trigger confiscation. This standard is so broad, it creates a moving target. It allows personal bias and emotion to override objective standards. When legal definitions become this flexible, it's no longer law enforcement. It's legalized uncertainty. And in that uncertainty, gun owners will be the first to lose their rights. Chapter 7. Supreme Court Precedent Ignored. The Supreme Court has already ruled unanimously in Coniglia v. Strum that warrantless home entry and firearm seizure without due process is unconstitutional. Yet this new policy appears to violate that very ruling. Instead of requiring a warrant or a clear emergency, New York allows officers to sidestep both and act on their own discretion. In Coniglia v. Strum, the court ruled 9-0 against warrantless entry. The decision rejected the idea that community caretaking applies to homes. It affirmed the sanctity of the home under the Fourth Amendment. New York's law revives the very logic that the Supreme Court struck down. This is not just a legal oversight, it is a direct challenge to the Supreme Court's authority. It reintroduces unconstitutional practices under a new name, banking on the assumption that no one will fight back. But that fight is already starting, and the legal consequences may be massive. Chapter 8. Legal action is underway. Second Amendment advocacy groups, legal experts, and constitutional attorneys are preparing lawsuits against New York's new policy. The language of the law, combined with its direct contradiction to federal rulings, makes it vulnerable to legal challenge. Some organizations are already outlining arguments that will test the law in both state and federal courts. Multiple lawsuits are expected to be filed in the coming weeks. Challenges will likely cite Coniglia v. Strom and Bruin. Constitutional groups are calling the law openly defiant of precedent. This could quickly escalate to emergency injunctions or appeals. These lawsuits are more than legal technicalities. They are a defense of the Bill of Rights. Every challenge sets a precedent. Every court hearing could restore or further erode the rights of every gun owner across America. And depending on the court's response, this could reach the Supreme Court once again. Chapter 9. The hidden agenda behind it all. Many believe that New York's real goal is not just public safety, but gun control by other means. If the state can normalize confiscation without trial, it sets the stage for broader disarmament. And by doing so under the guise of mental health or safety, it avoids the constitutional scrutiny that traditional gun bans would face. This law builds a foundation for future, more aggressive policies. It introduces a confiscation process that requires no legislation or vote. It shifts the narrative from rights to risks, making defense harder. It softens the public to the idea that gun ownership is conditional. This strategy is subtle but effective. It does not ban guns. It erodes ownership through fear, confusion, and bureaucracy. The result is the same: fewer armed citizens, more government control, and a legal precedent that could be copied nationwide. Chapter 10. This is coming to your state. New York may be the starting point, but it will not be the end point. History shows that once one major state adopts a law, others follow. California, New Jersey, and Illinois are already watching closely. If this policy survives the courts, expect copycat laws that expand its reach and solidify its methods. New York is often the testing ground for national policy trends. Other states are already discussing similar enforcement models. If courts uphold the law, it will signal green lights nationwide. The federal government may even attempt to model future guidelines on this framework. This is how rights are lost. not through one dramatic law, but through repeated erosion until resistance feels impossible. Every gun owner in every state should be paying attention. The battle over this law is not just New York's, it's America's. They are betting you won't fight back. New York lawmakers are banking on silence. They are counting on you not knowing your rights, not understanding precedent, and not standing up until it's too late. But history has shown one thing. When Americans fight for their rights, they win. If you believe in the Constitution, if you value your home, your family, and your freedom, it's time to act. Share this video, support the lawsuits, and most of all, stay informed. Because the next time a knock comes at your door, the law may already be standing behind it, ready to take what's yours.